I'm Jim Copeland, and I'm a senior fellow and director of legal policy with the Manhattan Institute for Policy Research. It's my pleasure to get to moderate this discussion today with General Pruitt. And I want to emphasize, though, that it's not just the Legal Policy Center and effort that has an interest here. Manhattan Institute has a lot of state and local efforts. My colleague Isaac Gorodetsky directs those efforts. And we've been working for years with the states, and that's really, to some degree, what the Manhattan Institute is particularly known for, are its state, local, urban types of events. Early in my career at the Manhattan Institute, which is 12 years now, one of my first big events and my first big out-of-town event was to the state of Oklahoma. And we came out with a report, our first Trial Lawyers Inc. report on the litigation industry in the fall of 2003. Our next edition of this is forthcoming. And in that report, we sort of talked about the problem of lawsuit abuse. Texas had done a bunch of tort reforms under Governor Bush and then under Governor Perry. And Oklahoma wanted to get in on the game. And so we had a big event out there. John Stossel, who's here today, was our keynote speaker. We flew out to Oklahoma City, and the Oklahoma Chamber of Commerce filled the room with 650 people. It's the biggest MI event I've ever been to. So quite a successful event. And Oklahoma did ultimately pass tort reforms. The courts threw some roadblocks up, et cetera. But they've been a leader on that. And it's one of the issues we can talk about with General Pruitt. General Pruitt is someone that The Economist has called President Obama's most committed adversary. And George Will, our friend George Will, the syndicated columnist, said that he's one of the Obama administration's most tenacious tormentors. So it's not unclear where he stands on many of these issues. And one of the things he's really been leading the fight on nationally is the preservation of federalism principles. So he's the Attorney General for the state of Oklahoma, and he's trying to make sure that the balance of power between the states and the federal government is as our constitutional framers intended it to be. So he created in Oklahoma what he calls a federalism unit, and it really pushes back against the overreach of the federal government. So we'll talk about some of the litigation and cases there. He was first elected Attorney General in 2010, ran unopposed, re-elected in 2014. And before he was the Attorney General, he served for 8 years in the Oklahoma legislature and the state Senate. Authored what would have been the largest tax cut in the state's history. Before that, it's interesting, he played collegiate baseball at the University of Kentucky and actually owned for 7 years the local AAA baseball franchise there in Oklahoma. I think while he was running it, it set attendance records and merchandising records. So he's got an interesting, successful business background as well. So just to get us started, General Pruitt, it's no secret that you've been relatively unafraid to resort to litigation, state-sponsored litigation, in response to regulatory overreach against the federal government and against other states. Can you tell us a little bit about why you've turned to this, how useful it's been as a tool while you've been Attorney General, and do you think it's something other Attorneys General also ought to be thinking about more?
Well, it's good to be with you, and thank you for that very kind introduction. And we did, in fact, set up that federalism unit because I felt as though states needed to have more focus on joining together to respond to the overreach that we've seen, particularly over the last, during this president's administration. And we forget oftentimes what federalism equals. I mean, we think about it strictly as a legal concept, but it is something that impacts people in a very real fashion. We know about the horizontal checks and balances between the branches, but what we forget about is the vertical separation of power between the federal and state government called federalism. And the constitutional framework establishes that. But Congress has as well in many instances. And many of the cases that we've been involved in, as I was sharing at the table, sometimes are less constitutional and more about statutory enforcement because Congress has spoken very specifically, very prescriptively, particularly in the environmental space, with respect to state implementation plans and under the Clean Air Act. And you see this EPA and you see regulatory bodies at the federal level displacing that or duplicating state power. And so it's a combination of things, Jim. It's the constitutional focus, but I think it's also statutory enforcement. And this federalism unit that I have is focused upon the litigation, but we're involved in filing comment during the APA process. We're preparing obviously amicus that we get other cases or other states involved. And so it's a multifaceted approach, monitoring all regulatory action, not all, but those agencies that are particular to Oklahoma, particularly in the energy space. But we monitor regulatory action, we're monitoring executive orders, we're taking steps through litigation and otherwise to make sure that our voice and our position is heard in the enforcement aspect. And so it's a very, very important process that I think states have been involved in since 2008. You know, you don't recite, there's an ancient saying, you don't recite poetry to one who's not a poet. When you meet a swordsman, you draw the sword. And I will tell you that with this federal government presently, with this administration, the sword is drawn quite often, and the states need to respond in a reciprocal way, and we are. And multiple states are doing that in the immigration context, in the healthcare context, in the energy context, in the banking context with Dodd-Frank, and we're seeing success. And so it's a very important endeavor by the states at this point. I think the attorneys general across the country actually have been the most important folks in responding to the regulatory overreach and the federal government's overreach since 2008. We have the access to the courts, we have the authority of the Constitution and the statutory power that we have at the state level to go take on the federal government in these ways, and I think it's made quite a bit of difference.
That's great. Well, let's talk about one of those cases, and I'm going to go to the Environmental Protection Agency now because that's something that you mentioned in terms of regulatory overreach. You're involved in a fight with them now over their redefinition of waters, the waters of the United States. Tell us a little bit about this case, why you've launched on this type of litigation.
Well, I'm hopeful that many of you are aware of the EPA's action with the WOTUS rules, it's called, the Waters of the United States. But the EPA has taken steps and actually finalized a rule that redefines, if you will, what constitutes a water of the United States. If you go to the Clean Water Act today and look at the language of what constitutes a water of the United States, it's a navigable stream, navigable water. That makes sense because of the Interstate Commerce Clause, clearly. But the EPA, through this rule, modified that to say that so long as a water body has a nexus to a navigable stream or water, they have jurisdiction. And so in the state of Oklahoma, many of you have traveled there. You need to come more often. It's a great place. We do have good baseball there, but really good football these days. And so we're excited about the playoffs. But in any event, if you go to central or west Oklahoma, we've had drought conditions in Altus, as an example, for 8 years. We have dry creek beds that are dried 90% of the year in Altus, Oklahoma. Historically, the jurisdiction of that dry creek bed has been the DEQ at the state level, the Department of Environmental Quality, and the Oklahoma Water Resources Board, not the EPA. And so if there's any kind of economic development, farming and ranching, oil and gas, municipalities, towns, and the state of Oklahoma, it's their province to regulate. Through this rule, that's changed. Now the EPA has said that dry creek bed, because there may be standing water 10% of the year, and there will be a nexus to a navigable stream of water, they have jurisdiction over that dry creek bed, affecting all uses, land use, private property use of that land. And so it is a huge, I believe, overreach by the EPA, and as such, you saw 30+ states initiate lawsuits against the EPA. Oklahoma led one of those, and I'm happy to report, if you don't know this, but we actually received an injunction against the EPA, and that rule has been stayed, and the merits are going to be litigated, obviously, over the next year or so. And fortunately, the litigation will be after this president leaves office. And so we've achieved, I think, a major victory. We've delayed the implementation. We've prevented the harm to private property owners in states across the country. We've stayed the EPA from acting unlawfully. And hopefully we get a new president in 2017 that understands what a statute says and applies it the right way and doesn't allow an EPA or a regulatory body to create things after the fact. I mean, this is something that I talk about quite often. Rule of law should matter. I mean, one of the greatest challenges we have as a country presently is that the regulatory uncertainty, because we have agencies in the banking context, we have agencies in the healthcare context that are truly enacting rules and regulations that are not tethered to the statute. And so when you're regulated as an industry and rules can come down and change 6 months from now, how do you plan over a 3 to 5 year or more process? How do you deploy capital? How do you hire personnel? How do you sit around a table and say, you know what, we're going to look at the statute and make decisions based upon that static, stable law? You can't do it these days. And so the regulatory overreach, the agency abuse of rule of law has created such uncertainty. I think it's what's caused there to be such anemic growth, economic growth in this country. People talk about tax policy, and that's understandable. But I'll tell you what, the greatest thing the next president could do is provide regulatory certainty and get back to respecting rule of law and certainty to those that are regulated in all of these various contexts. Just a thought.
I'm all for that. So let's talk about another case where you've also emerged victorious recently, the Fifth Circuit. This is one people I think probably have heard something about, and this is the president's executive order on immigration. You watch Saturday Night Live, you see spoofs of this policy. He calls it DAPA, the Deferred Action for Parents of Americans and Lawful Permanent Residents Program. But I'm sure there's a variety of opinions in this room about how we should handle immigration. But I think most of us in this room were probably taken aback a bit when we saw the president taking this action. Why exactly do you think it's important to challenge this action? And tell us a little more about that case.
Well, this actually was an extension of what the president did in 2012. He actually did something called DACA in 2012, Deferred Action with Respect to Children, and then he extended that authority to parents, as you indicated recently. And this is quite amazing. But the president is unapologetic. Sean and I were just talking about this. The president has said unapologetically, Congress has not acted. They've not passed immigration and naturalization reform, or they haven't done it the way I think they ought to, so I can pinch hit for Congress. And I'm going to do that through executive order. That's effectively what the president did with his immigration order. Now, you may not like the fact that Congress has been dysfunctional with respect to immigration and naturalization, but the legislative prerogative is to what? To legislate or not legislate. That's the legislative prerogative. And just because the Congress doesn't do it doesn't give the executive branch the ability to pinch it and step into space. And the president has done that through executive orders. And by the way, they're not executive orders. They're executive memoranda. And it's not legally significant, but 26 states responded to the president's unlawful action, joined together, sued there in Texas. My good friend Ken Paxton and I are joined together on that case, and we did receive a stay of enforcement on that action as well. The Fifth Circuit has upheld that. What's interesting of late, the president and the administration, the agencies involved, there's been some accusation that they're trying to still grant status or grant protections inconsistent with the stay that's been issued by the Fifth Circuit. And so we've had to take the Justice Department before the Fifth Circuit and say, look, you need to deal with this. And there's been some very heavy-handed language handed down by the Fifth Circuit in oral argument that they're very frustrated with the Justice Department's approach. There's not a respect for rule of law, first and foremost, by this administration, but even court orders like this one, this administration is trying to wink at. So we're continually monitoring that. But it was a great victory. Again, irrespective of what you think about policy or politics around immigration, we ought to respect the process. That's what matters the most to me. It's more transcendent, honestly, than these individual issues, healthcare, Dodd-Frank and the rest. Obviously, very important policy decisions that Congress and the executive branch are engaged in. But the process of enacting those laws, enforcing those laws, and then the regulatory bodies postscript, we need to make sure that rule of law is respected, and it's not been with respect to immigration.
Well, let's shift gears a little bit and talk about a different type of state-sponsored litigation. We've been talking about your suits against other governments, other government bodies. But a lot of states have been very involved over the last 20 years in suing businesses and outsourcing those suits to the private sector. This is something I've written a lot about, I've testified to Congress about, and something that we really followed. The big suit here was the tobacco litigation on behalf of the states that wound up being about a $30 billion settlement. Since then, though, we've seen over and over again multiple states filing these suits, often across the board. And the critical rub here is that they're outsourcing the work to plaintiffs' lawyers and giving them a contingent fee, a percentage of the cut, as if it were a private lawsuit with an individual plaintiff or class of plaintiffs. So tell us a little bit about your approach to that issue in Oklahoma. What are some of the pitfalls there? What do you think we ought to be doing about that?
It's a very important issue that Jim has raised, because attorneys general have in fact deeded authority in certain instances to plaintiffs' attorneys and outside attorneys in the prosecution of cases. I was actually in the legislature when the tobacco litigation was filed. And I think it was we saw it recently, by the way, too, with respect to the mortgage debacle from 08-09. The Justice Department, the states, all 50 attorneys general were involved in an investigation around the quote-unquote abuses that occurred in 08 and 09, 08 with respect to the mortgage aspect, dual track and robo-signing and the rest that took place. 50 states were involved in the investigation. I actually was elected in November of 2010, took office in January of 11. I sent a letter to my colleagues in March of 2011 saying, this is fast becoming a situation where we're trying to leverage industry to get money. This isn't about taking care of those that have been harmed. This is more about, it's starting to be more like the tobacco litigation. Ultimately, a year later, Oklahoma was the only state in the country that didn't sign on the mortgage settlement because of that issue. I said no and went out and prosecuted those banks, those mortgage servicers that defrauded Oklahomans, and got my own settlement of around $16 million. And those monies actually went to those that were harmed, and didn't go to attorneys, and did not go to others that the consumers were not protected, I think, in the national settlement. And that's actually been borne out in Congress. So the point you're making is very, very real. And you see it particularly in the consumer context. You see it in the pharmaceutical context, where states will join together in a multi-state way and then leverage industry to extract, in many instances, money. And it's wrong. And so what I've done in Oklahoma, we sometimes use outside counsel. For instance, we've got a water litigation. We've got 37 tribes in the state of Oklahoma. 2 of those tribes have sued the state, saying that they own water in 17 counties. Actually, I'm of a different opinion. And so I'm defending the state's interest there. There are probably less than 5 attorneys nationally that have the expertise in tribal and water law. And so we've retained an attorney out in New Mexico that is partnering with me in that regard, but we're first chairing it. It's not contingency. We're using that attorney as a subject matter expert and not deeding the authority away. So we're litigating it, they're second chairing it, and we're maintaining the state's position. That's what I think needs to occur. I think it's contractual. I think some legislatures, Jim, are actually looking at it as well to make sure that there may be some caps with respect to the amount of money that can be paid on contingency. There is a place for retaining outside counsel. It should be the exception and not the rule. And I think in certain instances, states have used it as the rule and then allowed someone else to kind of carry the imprimatur of the state, to advance it to benefit, plaintiffs' attorneys and the recoveries.
How about the criminal law now? We focus a lot obviously the Manhattan Institute's very known for street crime, violent crime. My colleague Heather McDonald, a national leader on this subject. Our legal policy team has focused a lot on what we call overcriminalization. These issues are being debated right now in Washington. We've spoken at a number of states and written some reports on what's happening at the state level as well. What we're talking about with this is really a twofold problem as we see it. First, the proliferation of crimes. Unlike the violent crimes we're really worried about, the rapes, the murders, the assaults, we're talking about regulatory code crimes, which number in the thousands in terms of laws federally and in most of the states we've studied, and it swells to hundreds of thousands when you look at the actual regulatory rules that have criminal penalties backing them up. So the average citizen, the average family farmer, the average entrepreneur isn't aware of what might or might not be criminal. If you don't have a team of lawyers advising you, you're at jeopardy. And similarly, you don't even have to show intent in a lot of these cases, so you don't have to do what traditionally was required and show that you had a guilty mind. Here, if you accidentally break a rule, you theoretically could be facing jail time, and there's anecdotes of that. How much of a problem do you think that is in Oklahoma? What might we be doing about it?
Well, it's a problem nationally at the state level because of the budget constraints and difficulties that states are facing. Because like in Oklahoma, you can't raise the income tax without 3/4 of the legislature passing it, and then the people actually have to approve it as well. So we're not going to raise taxes in Oklahoma, thankfully, okay? But what does that mean? That means that the legislature is then using other means to raise revenue, and they're doing it through fines and penalties. And I think what happens oftentimes, Jim, is Raphael and I were talking about, is they will attach criminal enforcement to these regulations in order to leverage huge fines and assessments on regulated entities and industry. And so I think it is a significant concern that we need to address at the state level. And I love the way that you phrased it. We need a mens rea requirement, with respect to these the criminal aspects of the regulations, because a default, if you will, I think as you all have talked about.
Right.
Because it will provide protection to regulated entities and persons to offset those abuses, some due process concerns that we need to address. So it's something that in Oklahoma, I'm excited to actually work with you guys in that regard to try to, I've been involved in a state overreach project. I started it in February of this year. I went to my solicitor and that federalism unit. I said, we focus so much on overreach at the federal level. There's quite a bit of state overreach as well. You know, these companies like Airbnb and Uber and Lyft and Zenefits and a lot of companies that you may be familiar with, as they come in and deliver services in these markets, you have regulatory agencies at the state level and sometimes at the local level that look at the statute that may have been there for decades, that look at the new business and say, oh, I've got to regulate them, right? Because the stakeholders that I regulate already are complaining that the market's being disrupted by these individuals, and so I've got to extend my reach there to make sure that everything's fair and equitable. And so they'll extend their reach against an Uber or a Lyft or an Airbnb, and the statute doesn't give them that authority, period. And so you have state overreach as well, and so we're actually going through a process in my office where I have the authority called AG opinions. You can actually issue an opinion in response to a request by a legislator or a board and commission, and that opinion carries the full force of law as a judge, as a court, unless a court later overturns it. So I'm actually issuing AG opinions, overseeing agencies at this point, saying, no, you don't have authority or jurisdiction there, and trying to contract that regulatory reach. But this is another example of regulatory bodies at the state level exceeding their authority and using their power in a way to pick winners and losers and to generate monies for the state. So I think it's a huge area of emphasis and should be. So I commend you for that.
Well, good, and we're always enthusiastic to work with elected leaders that are on our page in a wavelength. So we look forward to that. Let's just shift before I open up to audience questions, and I want to shift gears one more time and talk a little bit about the broader political scene. You've obviously been very successful politically there in Oklahoma. We're in the midst of a campaign for president with I guess there's pretty much a presumptive nominee on one side, the other side, the R side, you're an elected Republican official, lots of candidates out there. Without necessarily talking about any of the specific candidates themselves, what's your feel for the tone of the debate, the issues that are being raised, and what optimism do you have, what concerns do you have, particularly speaking from politics as you know it there in Oklahoma, but more broadly for the country?
You know, generally I would just say that I'm concerned about the toxicity of the debate right now. I mean, one of the things that I think is sorely lacking with political discourse is civility. I mean, I think that, you know, I've long been an individual that stand on conviction, you know, seek to cajole and persuade those, you know, in the political context, but do so with civility. And that's just non-existent right now. And I'm very troubled by that because we have such large issues as a country that we need to deal with, that unless we can engage in a meaningful debate, a meaningful discussion about solutions around those issues or challenges, we will not see outcomes. And I think that's where we've been for some time. It's a zero-sum mentality that we see in Congress and we see in the political discourse. I shared with some business owners in Enid, Oklahoma, about 6 months ago, and having been in business for several years, I asked them the question. I said, now, as you're all doing deals, as you business folks are doing deals, how many of y'all sat across the table and said, now, here's what we're going to do. I want 100% on my side. You get 0. Now let's do the deal. And there wasn't one person who raised their hand. I mean, that's not how business deals are put together, right? Business deals are put together where you try to sit across the table, find mutual interest, and find answers and solutions to satisfy both sides of the table as best you can. Why should we expect anything less of those that we put in Congress? Why do we have this zero-sum mentality where we're just looking at the jersey color, and so long as the jersey color matches mine, I'm for that, and if the jersey color is not mine, I'm not for that, and we don't engage in meaningful debate and discussion. And so we need, and we should want that, right? We should want that as a country. And I think that's the most troubling thing I see right now with the presidential, I'll call it debate, discourse, what have you, is that it's more about political entertainment than it is on substance. And so prayerfully it will change soon. I think the mood of the electorate is and I will be partisan here for a second, forgive me. But I think when you look at where the people are, I mean, I think Democrats right now look at the Republican side and they say, they're so combustible over there. They've got so many folks that are involved, and people are upset, and they don't like what's going on in the establishment, and they don't like what's going on in Washington, D.C. They think that's limited just to Republicans. That's not true. That's where people are. People are they're looking at what's going on. They say, I'm sick of all this. Democrats, Republicans, I'm just sick of. And so when you think about that kind of mentality or attitude that I think is prevalent in the voters right now, they will nominate the most establishment candidate you could ever put on the ballot on the Democrat side. Now we'll see what happens, but I like where we are from an issue perspective, an ideology perspective, and where the voters are, and I'm hopeful that. Look, we need a different mentality and view in the White House in 2017. I mean, the issues that I've dealt with as Attorney General, that we've dealt with as states, we've lived firsthand a command and control attitude of Washington, D.C. I mean, the greatest criticism you can levy against this president is that he's full of hubris. I mean, he believes that he has all the answers, no one else does, and they're going to command and control the states, and they're going to run roughshod over statutes, over constitutional framework, and they're going to dictate and control and that's what they've done. That's not editorial comment, by the way. I mean, case upon case upon case upon case, we can show that that's occurred. We need a more humble president. We don't need a president that has all the answers. We need someone that recognizes and respects the framework. Both horizontally with the other branch and vertically with the states. That's where we've been as a country. And then we need to engage in more civility and more discourse around. That's the reason I'm very encouraged about Speaker Ryan. I think one of his key attributes is that he's a thinker. He's an idea entrepreneur. He leads based upon policy, and I think that that's something that's going to matter, in the future. So I'm hopeful where we are as far as where the voters. I think what they're wanting. I pray we get a nominee on the Republican side that embodies that. And then we have a different attitude in Washington in 2017 because we desperately need it.
Great. Well, I think we've got lots of folks in the audience who may want to ask questions. I'll go here to JP first. Wait for the mic and then identify yourself.
Thank you for your remarks, Mr. Pruitt.
Thank you, JP.
Have you calculated what the actual cost is of regulatory overreach, either at a national level or, if not,
So I think the question is has he calculated the regulatory costs nationally or in Oklahoma for many of these policies you've been challenging? In
either
court?
the dollar amount or the cost in jobs, either way, or both if you have that data.
It's been done. It's not something I do in my office. I mean, it's not because I don't care about that or I'm not concerned about it. It's just not our focus. I mean, the decisions we're making are not based upon policy or politics. It's really based upon either the constitutional or statutory framework and giving meaning to those things in these lawsuits. And so there is clear impact. Obviously, from a standing perspective, you have to show harm, and we do that through the court in the process, and we document that to the point of establishing standing. But beyond establishing standing, I've just not been involved in the calculation of what does the WOTUS rule mean as far as loss of jobs or money or otherwise. And so, not that it's not important, it's just something I've not been involved in. But I think it happens. I think Leonard Leo is a good friend at the Federalist Society. I think he and others have we use that data when necessary. There used to be, we were talking about the number of community banks in this country were 12 to 15,000. They're now down to below 6,000, largely because of Dodd-Frank. I mean, you all know this. The dirty little secret about Dodd-Frank is that Bank of America and Wells Fargo and Citi love Dodd-Frank. They love it because they've got the regulatory, the legal, the heft, if you will, to navigate those waters. Bank First in Oklahoma City doesn't. And so I have heard examples of banks in Oklahoma of having to add 10 employees, spending $600,000 to $1 million of new money to comply with Dodd-Frank, which obviously affects their ability to lend and grow, and it's affected access to capital. I hear those kinds of stories often. But as far as a kind of a macro calculation with respect to Dodd-Frank or ACA or otherwise, that's just something that I consume that we don't generate it.
We'll go over here to Stanley next. Wait for the mic again and identify yourself.
Stanley Goldstein, thank you, General Pruitt. That was very helpful. Across the nation, many attorneys general levy big fines against business, New York State particularly, and huge amounts of money, the billions, come rolling in. What is the countervailing pressure against this kind of confiscation?
Are you referring more to what Jim talked about earlier as far as the regulated entities, the agencies assessing fines against industry?
Yeah. In New York State particularly.
Yeah. I think the answer is what we talked about earlier, and that's getting the legislature involved to deal with that overcriminalization aspect of those regulations. I mean, it has happened. States like Oklahoma, because we have $1 billion shortfall this year. We actually have to balance the budget at state level. The feds don't, as you know. And so we have $1 billion in cuts, and this sounds like pocket change, obviously, to states like Texas and California and Florida. Our entire budget's $7.2 billion. You know, so if you're going to cut $1 billion out of 7.2, it's a pretty significant cut, right? And so these legislators for quite a long time have been saying, okay, where do we capture revenue? And I think they've used this overcriminalization, this regulatory approach, these fines and penalties to offset their inability to raise taxes, either politically or constitutionally. The answer is to go back into the legislature, which is what you guys are looking at doing. And I've actually shared with Raphael and Jim, I want to dedicate resources in my office to actually evaluate those statutes that have criminalized this and then have a repeal effort of those statutes and actually roll it out this next spring. That's I think a good first step.
So up here to Ken.
Ken Gilman, going back to the extensive overregulation by the feds, there's a concept that has evolved over the last 70 or 80 years where the courts have said we need to defer to the regulators in terms of their interpretations. And it's reached the point where we've got the kinds of overreach that you've described. Do you see any way of reversing that? Do you see any trends? How do we reverse that course?
I mean, you're speaking of Chevron deference, and Roberts in a couple of opinions, Scalia as well. I think there's been messages sent in the last, particularly with the EPA in the last two terms. The Michigan versus EPA case that came out, where the EPA disregarded the cost-benefit analysis with the mercury rules, I recall. You're starting to see the court be a little bit more intentional about not deferring and speaking directly to Chevron deference. We need to kill it at the state level for sure. We at the state level, we ought to take steps that are concrete and real legislatively to remove that deference. And I think the other thing that can be done legislatively at the federal level is make Congress actually approve those regulations that are, if the EPA puts out a clean power plan, make Congress vote on it. You know, this delegation issue, it's deference and delegation. You know, you see Congress basically not doing its job. I know it's going to shock everybody in the room, right? So Congress not doing its job and saying, you know, we like clean air, EPA, so go make clean air. Okay? And so the EPA goes out and does what they think needs to be done on making clean air. Well, obviously that's inappropriate delegation by Congress, and then combined with Chevron deference, the courts are saying, well, who are we to step in? One, if Congress wants to delegate its authority to an administrative agency, who are we to stop them from doing it, which they typically don't, and they should. And then secondly, with this Chevron deference, the agency gets a double strength there. And so both need to be addressed federally and at the state level. I'm starting to see courts, I think, be a little bit more responsive to that. This last healthcare decision, you know, the state healthcare exchange decision, there was some embedded language in that case where Roberts, I think, took head on Chevron deference. So I'm encouraged, but we got a long way to go. We got a long way to go.
Over here, Michael.
In a regulatory state, when you live in a country where the regulatory bodies are as powerful as they are in this country, you better get back to checks and balances as it relates to how they do business. And that deals with delegation and it deals with deference. And both have to be addressed, I think, in aggression.
My name is Michael Myers. I'm the Executive Director of the New York Civil Rights Coalition.
Hello, Michael.
My question is in the context of Oklahoma University.
Oklahoma?
Yes.
You're a fan? Boomer sooner. Maybe not. I don't
question,
know.
My question relates to
Yeah.
regulation, overregulation, and the overlay of Title VI and Title IX, and even state and campus regulations, which seek to restrict student speech, symbolic speech, racial speech, dissenting speech, speech on and off campus, because they think that speech offends people because they're racial minorities. I don't hear any state attorney generals. If you have, I apologize. I haven't heard any state attorney generals pushing back to defend free speech, the free speech rights of students. And I want to know, what is the role of the state attorney generals to tell campuses, public universities, they cannot, may not use Title VI or Title IX or state, quote unquote, or campus regulations to restrict free speech of students?
Well, first and foremost, we don't have a constitutional right not to be offended, right? And I think that people forget that. In response to your question specifically, it varies by state, because in Oklahoma, as an example, the higher ed regents are actually a constitutional entity. And so in some states, the higher ed system takes on constitutional status. In other states, it's statutory. And so I think their reach and authority and power, perhaps in Oklahoma, is a little bit more powerful than it might be in a state that they're not a constitutional entity. But I think attorneys general, like in Oklahoma, I can offer an AG opinion, as I indicated earlier, with respect to constitutional issues, and it's advisory. It's not enforceable. So you can speak to these issues, I think, more in that regard, and perhaps influence the debate. But as far as enforcement, at least in our state, it's a little bit more challenging because the status of the higher ed institutions and regents that govern them. That's not always the case, though. And so I think there needs to be a state-by-state review in that regard. But you bring up a very, very good point, and I think it's something that's merited to review and discuss with respect to my colleagues on how we can address that free speech component and make sure that it's addressed in an effective way, because it's paramount right now. You're seeing a lot of discussion at the state level in that regard. We had a president of Oklahoma Wesleyan speak to it very, very aggressively in a way that I was very encouraged. You know, he didn't, these safe zones, and he dealt with that head on. And I think we need more leadership. We'll write President Boren a letter, and former Senator Boren, and let me tell you, you talk about he'll respond. I mean, and I think it's a great thing to discuss with him. I appreciate you bringing it up.
Hi, I'm Bob Weisberg. I taught political science for 40 years. During 20 of those, I taught about federalism as part of the introductory American government class. And I can tell you, it was perhaps the most boring series of lectures I gave.
Oh, that's too bad.
I love the subject.
Oh, come on
I know.
now.
Even by my standards, it was boring. Now, I've also
Now,
noticed...
it's been exciting today, hasn't it?
Okay.
Yeah.
I've also noticed that federalism as a subject in political science is evaporating. And I
Imagine
suspect... Yeah.
Imagine that, right?
It's not sexy. So my question to you is, what are you doing to make sure that we don't lose sight of what federalism is? And have you ever thought about doing what many other organizations do, holding seminars for people in the mass media, legislators, people of influence, to reacquaint them with these extremely important principles, so when they go on the air, they at least know what general revenue sharing was, and they at least understand the basic arguments offered by the founders, how federalism is a protection against tyranny. I mean, I watch TV and I see the internet, and you almost never see federalism come up in any context whatsoever.
Well, a couple things. I actually have a civics initiative that we are involved in my office. Actually, Senator Coburn and myself have engaged in a combined approach to go into elementary schools and help even K through 12 understand the importance of our checks and balances, our constitutional framework, and we get into those issues around federalism. We may not use that term specifically, but that civics initiative, I think, is very, very important across the country. I think that's terribly lacking. And as far as, I actually have legislators, during the session each year, I'll invite freshmen over, And then I'll also extend invitations to the committee chairs and the legislature generally. And I'll have discussions with them around these very principles on steps that they can be taken. So we have taken kind of an education approach, both on the legislative side as well as the educational side. But look, I think people get it more than you think. I've received polling data. They may not call it federalism, but they get checks and balances, and they get government overreach, and they get our constitutional framework and why it's important to preserve liberty. They get that more so than maybe if this administration's been successful in anything. It's raised the level of awareness that the way we do business as a country matters, and you can't have a president that disregards those and in effect, your life. I mean, the reason the Affordable Care Act challenge was so powerful around the individual mandate is that people fundamentally understood that it changed the nature of the relationship between government and citizen, and it did. And we see that being played out in many instances. So I actually think that people more so today than ever get federalism principles. Now, whether they use that term or not, we can debate, but I think they even use that term more than you think. We'll see, but I appreciate your comment, and I have been involved in trying to, both educationally and with the legislature, take concrete steps.
Roger, send his hand up. Roger, if you just wait and identify yourself, thanks.
My name is Roger Moak. I'm an insurance and reinsurance arbitrator here in the city.
Hello, Roger.
I can't tell you how much of a breath of fresh air it is to hear you talk. It's hard for us, those of us who live in New York, to imagine that somebody like you holds the office that you hold, because our history of state attorneys general in New York is quite different.
I understand.
The problem with among the problems with the office here in New York is the fact that every attorney general is running for governor or senator the moment they're elected attorney general. And they don't perceive that there are any boundaries. Talk about overreach. They don't perceive that there are any boundaries at all on their own jurisdiction. Doesn't matter that there's an SEC. Doesn't matter that there's a Department of Financial Services. If they look around the landscape and they perceive something they don't like, they think they can barge into the regulator's jurisdiction and bring a lawsuit and curry favor with the voters. Now, that's our history. Have you any experience with such a thing, and is there any hope for us who live with that kind of an environment?
There's always hope, because voters matter. I mean, I'm not one of those folks that believe that incumbents just naturally get reelected. I think the folks can respond, and we've seen that in different parts of the country. I mean, we have 27 attorneys general now that are Republican attorneys general, and we have several Democrat, in my view, attorneys general as well that share principles like we've talked about here today. And so I think there is a shift that's happening at the state level, and so there's always hope. Perhaps a little bit more cloudy in New York, but there's hope. As far as what can, experiencing that, yes. I mean, I think I mentioned the mortgage settlement. Attorneys general have a very fundamental, important duty to deal with those that defrauded consumers in the mortgage context, and that was statutorily empowered and statutorily right to do with the dual track or the robo-sign or whatever the case may be. But what happened is you had attorneys general at the state level partner with Eric Holder in the Justice Department and as an extension of the White House to craft a process that leveraged banks. I don't know if you tracked that or not. $25 billion. Everybody made a big deal about the $25 billion that equaled that settlement. Do you know that only about $3.5 billion of that was actual cash? $3.5 billion. 20 plus billion of it, I don't remember the exact numbers, and we can get them to you later. It allowed Bank of America and Wells Fargo and Citi to go into Florida, Ohio, California. Remember when it took place? In March of 2012 is when the settlement took place. I'll never forget, I got a phone call from my colleague. I'm not going to name the colleague. He was a Republican colleague. He was on the way to the press conference in Washington, D.C. that he was going to have with Eric Holder and the president with respect to announcing this settlement. And I'd share with all my colleagues I'm not in. He called me 30 minutes before as he was going to the conference and said, "Scott, are you sure?" And I thought for a second, actually, because it was a big deal. I mean, it made me look like I was being insensitive to those that had been harmed in my state. Now, we took another approach, but it was a tremendously risky thing to do. But it was the right thing to do because we were exceeding our authority. We were leveraging. And moreover, the $3.5 billion, you know what they did? It was almost like a class action. They sent a check, literally, to individuals that were quote unquote harmed. I think it was $1,200, maybe $1,200 or $1,500. Irrespective of your harm, you got a check for $1,200 or $1,500. Our recovery was 10 times, sometimes 20 times that, because I wrote checks directly to those individuals. We went through every file in Oklahoma to determine the level of harm and then provided direct reimbursement to them based upon the enforcement we took against those entities. So what it takes, I think, is a discussion among, I had that discussion with my colleagues. We shouldn't have done what we did. We should have had 10 or 15 or 20 states not yield to that, right? And not take the approach of what other AGs have done historically, which is take their authority. It's what Jim was talking about earlier. Leverage that authority, leverage an industry to extract. The tobacco litigation, I don't smoke. I don't get this, by the way. In places like Colorado, tobacco is such a bad thing. We're going to eradicate it from the face of the earth, but marijuana is good. You know, I understand I understand the state aspect, but the tobacco thing, as much as you like or dislike tobacco, what happened with the tobacco industry as far as the court process was quite remarkable. You know, how the states joined together to extract a settlement in the billions of dollars. So it's something that matters who you elect. It matters how they lead within the confines of that office, and it matters how they work together post-script election. And we just have to make sure that people are committed to those principles. It's a long process. But there should be hope in New York. Y'all have elected folks that, maybe not, I don't know. Governors, right? Governors that have embodied some of these principles.
But the Attorney General is independent of the governor, totally independent of the governor, so it doesn't matter.
In front here, for going around. Thanks.
Yes, sir. Oh.
I don't know if you have this in Oklahoma, but we have it in New York. New York governor says, bring your business to New York, we'll waive your taxes for 10 years. Or New Jersey says, well, come to New Jersey, we'll give you more. And and big companies, you know, major corporations are paid money, taxpayer money, basically to the highest as to which state they go to. So my first question is, do you have neighboring states where you're sort of competing with each other for jobs and you're subsidizing, causing the taxpayers to subsidize rich companies? If the answer is yes, then it really ties into federalism. Unfortunately, we all know what the Constitution says about states are supposed to take care of, you know, health, education, welfare. It's a federalist system. The Constitution said. Except the Supreme Court has said many years ago in Wicker versus Filburn, even a farmer growing wheat on his own, for his own use has a, quote, effect on interstate commerce. So we're dealing it, unfortunately, and I tend to think both the Republicans and the Democrats, I don't think either one is necessarily saying we should, well, first it won't happen anyway, overturn Wicker versus Filburn and go back to what the Founding Fathers originally said, which is states should do their thing and the federal should not meddle in the states. But we're stuck with that. So what is your view on maybe accepting the fact that there is Wicker versus Filburn and everything, the Supreme Court basically trumps whatever the states do if it affects interstate commerce, and because they could outlaw what goes on between the states. They could say no state should subsidize anything other than needy people instead of rich corporations, and I'd be interested in your views.
Well, look, I mean, we know that the Commerce Clause is not plenary. We know that. We know that from actually the Affordable Care Act challenge from 2010. I mean, when the Attorneys General brought the initial laws, when we brought it in 2010, you remember the course of criticism, right? That it was being done just because in an election year, there was no constitutional basis to it. It was to embarrass the president. That was all March of 2010. March of 2012, I was in the Supreme Court, 3 days of argument, dedicated to the ACA, had never been done since Miranda. That's how important the case was to the court. And we know, and this is not talked about, but the holding in that case indicates that the Commerce Clause is not plenary. And so now what the boundaries are, obviously, are
Plenary mean?
just all-encompassing. I mean, it's to the gentleman's point that the Commerce Clause gives ultimate authority, general authority to Congress to usurp, displace, preempt state law. And it's plenary in power. And the federal government doesn't have police power, as you know. States do. The federal government does not. And so, but to your point specifically about what can be done, look, a president can be committed to vetoing laws that fall outside the enumerated powers of the Constitution. You could elect someone as president in 2016 that's committed to saying, look, the enumerated powers matter. And we're going to get back to a federal and state construct that truly does give general power to the states, and we're going to make sure that the agencies and Congress puts things on the president's desk that fall within the enumerated power. Now, obviously, there's a matter of interpretation and application, but you could have someone much more intentional about that enforcement than what we've seen historically. The problem with all this is you have people in Washington, D.C. that want to fix things. And so there's a problem with education, and they say, well, we need to do something about education because the pollsters tell them that if you talk about education, you get elected. You know, education matters to people. So the person running for the U.S. Senate has to talk about education when he or she shouldn't really be talking about education, right? And so that dynamic needs to change, and I think that we need to encourage and exhort and actually engage in meaningful debate to say, look, play within your lanes, play within the space, and elect people that do, and be committed to it. But as far as the courts are concerned, I mean, I mentioned this earlier, deference and delegation with Congress, that needs to be dealt with. Deference, Chevron deference, the delegation that Congress is doing, I think, unlawfully. An executive that gets the role of falling within the enumerated powers of the Constitution, and states that are assertive. You know, we were talking about hydraulic fracturing, you know, before I got up here. My friends who are attorneys general in states, maybe even, New York could be included in this, they think that hydraulic fracturing just kind of happened like 10 years ago. We've been fracking, hydraulic fracturing in this country since the late 1940s. Oklahoma has been regulating hydraulic fracturing robustly since the 1950s. The revolution that's occurred is the horizontal drilling. It's the application to be able to go down 2 miles and left or right 2 miles, and then extract the natural gas and oil from the shale that you couldn't reach before. That is the unique technology that we didn't have 10 or more years ago. But what's the feds doing? What are the feds doing? BLM, EPA. The Clean Water Act says that there is no jurisdiction of the EPA in the regulation of fracking, hydraulic fracturing, unless there's a diesel component in the frac fluid. And so unless there's diesel in the frac fluid, there's no jurisdiction. But yet, what has the EPA done? They've engaged in a multi-year process on the regulation of hydraulic fracturing to displace or duplicate that which the states are already doing. So we just have to, we'll sue on that. We'll sue on that like we have these other things. And in that process, there also needs to be a dual track of the executive and the legislature, Congress, dealing with it as well. So it's not just one answer. I just think in the last 7 years, the answer has been the first response has to be draw the sword, right? And in response to the sword being drawn against you. It's a defensive posture. Does that answer your question, I hope? I don't know. I mean, I'm trying.
Well, General Pruitt, this has been a wonderful discussion. You are, as we've heard, in New York, we don't really hear political leaders speak the way you have, and we certainly don't see them act the way you have in office. So it's really our pleasure to have you here. We wish you all the best in your endeavors. Thanks for sharing with the audience. Thank everyone for coming.
Thank you, Jim.